You're listening to the Valley Current.
You're looking very corporate there, Michael. Oh, you got the baseball game going on in the background, huh?
Yeah.
So what did you think of this case?
I thought it was a good rule. I don't necessarily agree with how they got there, but I thought it was a good ruling.
It's her first, I think it's her first published decision as a justice of the Supreme Court, Justice Barrett, right?
Is that true? That usually they try. No, I think she had one earlier. Usually they
Really?
try
I
and
thought it was
Usually-
the first one.
I don't think so. The first one is almost always unanimous. And I think
Oh, is
she had
that
one that
right?
was unanimous with a concurrence. Yeah.
Okay. Well,
Yeah, I think this might be your second or third one.
okay, because this one has the dissent, and your point is they kind of let them get their sea legs first, I guess,
Right.
what your point is. They
Yeah.
don't want to slap them around. This one's got the Chief Justice in dissent with a couple of others,
Right.
including
What's
Thomas.
interesting about this one is it is, I believe, it's the first one that Justice Breyer has assigned.
Justice Breyer did the
Yeah,
assignment.
the senior most judge in the majority assigns who's going to write it. And so it's very rare now that Justice Breyer is the senior most judge behind the Chief Justice in this particular majority, which doesn't happen very often for him. He got to assign it.
Well, that's interesting because I thought that the Chief Justice was the person who assigns, but you're saying because he's in the dissent,
Right.
he loses the assignment right.
Right.
And so the most senior it would be Thomas next, but Thomas is in the dissent. So it flips to the next most senior, which is Breyer.
Right. So
Right.
Breyer rarely gets to make the assignment.
Right.
Because it's rare he's in the majority and also the most senior judge.
And Breyer is sort of someone that people have been saying should sort of be exiting stage left, if I'm reading between the lines of the scuttlebutt, right?
Some people are saying it explicitly.
Right. So, he comes from a family of judges. Of course, his younger brother is on the district court here, and I don't think is ever going to leave. I think he enjoys his role. Basically has a lot of power as a district court judge. Of course, not as much as his brother does. But let's just set the stage for the listeners because we're going to just do a quick summary. This is one of the few cases that I've seen where the Computer Fraud and Abuse Act actually makes its way to the U.S. Supreme Court. I don't think there's that many cases total.
There are not. And this has been a live issue in the appellate courts. And there's been a hot issue for many, many years. So I'm surprised it took this long to get to the Supreme Court. But this was the right vehicle, I guess.
Right. And yet when you read the decision, you sort of shrug your shoulders and say, this sounds more like pure statutory interpretation around several key words and phrases, maybe even arguably just the word so, S-O.
Well, that's right. I mean, that's really the issue, right? I mean, because none of the lower court decisions really did this straightforward interpretation. And so I've long blogged, like I blogged about this particular case, but then I copied back the old blogs I wrote. The behavior targeted here clearly falls, in my mind, within the scope of the Computer Fraud and Abuse Act language. But there's a big problem with that. And most of the appellate courts have seemed to agree. They've said it does, but they've used rule of lenity or void for vagueness or other reasons to narrow it versus the straightforward textual interpretation that was used here. So I'm skeptical of the textual interpretation, but I guess if you can get 6 judges on the Supreme Court to sign on to it, it is what it is.
Right. So what I like about what she did is the first 2 paragraphs tell the whole story. They tell the facts.
It's a pretty simple fact pattern.
Very simple fact pattern. A former police sergeant ran a license plate search on a database in exchange for money. Presumably someone bribed him. and said, I want you to do this search, probably a private investigator, probably he was helping him. He flouted the department policy. I guess he's a former police sergeant, not at the time he did the search. He was a police sergeant and now
he got fired.
He got fired. So there's an ambiguity there. She really needed to say a police sergeant, now a former police sergeant, but maybe she's trying to use Occam's razor and say, you could figure that out. And says, she quotes the operative language. We must decide whether he violated the federal act from 1986, which is, basically 25 plus years old, which makes it illegal, regardless really of the content.
Dude, 35 years, we're old.
Huh?
It's 35 years.
35 years, excuse me, 35 years.
Yeah, that's how old we are.
Yeah, my goodness. I was trying to be younger, Mike. To access a computer with authorization to use such access to obtain or alter information in the computer that the accessor is not entitled so to obtain or alter. So the word so ends up playing a pivotal role. And she says, look, this provision covers those who obtain information, blah, 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 to which their access does not extend. It does not cover those who, like him, have improper motives for obtaining the information that's otherwise available to them. And your point is, look, he didn't have the authority from an agency point of view to do what he did. So therefore he didn't have the power and therefore he violated the act.
He was not entitled to obtain it.
Right.
Her view is, well, so to obtain applies to the predecessor to access a computer with authorization and to use such access.
Right.
But okay, that's great, but that doesn't actually answer the question, because if you don't have the authorization because you're violating the rules, then you are not accessing the computer with authorization.
Right.
You're accessing. And so when I blogged about this week, it's like, just change your thing that says if you're logging on with nefarious purpose, your authorization is hereby revoked, and then this whole thing goes away.
You think so? Do you think it actually works just by dint of?
No, I don't, but it should.
Well, I'm not sure it does, because I think there's a bigger story. Usually with the Supreme Court, there's a bigger story for why they take a case and why they decide a case a certain way. And you have to read the tea leaves. But as I suggest, I think there's a trend that the Supreme Court is generally worried about an overburdened federal system with too much federal law, too many federal questions, too much federal jurisdiction, too many state law cases that should really otherwise not be in federal court. This case could have been a simple garden variety sort of breach of authority, whatever you want to call it, maybe even criminal case in wherever Van Buren was located. I forget where it was, somewhere.
That's a creative way to look at it. That's a creative way to look at it. I disagree. I think it's actually more a trend toward against overcriminalization.
Oh, a trend against overcriminalization.
Right. If you look at, everybody's like, look who it was. It was all the Trump populists who voted for this. But that's not really who voted for it. The people who voted for it were the libertarians, right? And the people who voted against it are the tough on crime corporatists, right? So Thomas, the Chief Justice, and Justice Alito, right? They're happy to come down on people. Whereas Justice Gorsuch and Justice Barrett and Justice Kavanaugh are much more in the libertarian vein.
Oh, so you see it more as to too much criminalization
of everyday conduct.
But the guy probably did commit a violation, probably a misdemeanor of some sort of criminal statute, right? Probably.
He did, but they're not worried about this guy. There, if you see up above, there's a paragraph that basically says, look, if you read it this way, then basically everybody's goes to jail for doing everything. And that's always been my problem with this provision, why I think it's a good decision, even though I disagree with the actual textualist statutory interpretation that they gave. I'm happy that they used whatever tools they had to limit the policy, because it basically, makes many, many things illegal.
Right. You're saying, like,
if several years ago called "Academics Go to Jail." You scrape a website, you go to jail.
Oh, this is the notion that, hey, there's a policy against you using the company's email system for personal matters or for going to a porn site or something like that. Now you violated authorization and therefore you violated the CFAA, right?
Yeah, forget about companies, websites. You violated the terms of use.
Right. Right. But look at the dissent. I think the marvelous thing about this case, and it should probably be used in law school, is that it's a very simple dissent. The dissent is like, look, this is just about someone that exceeds the authority. A valet takes possession of a car, rightfully he's supposed to park it, not take it for a joyride. Takes it for a joyride, he's basically subject to grand theft of the car, right? And that's the same idea that's being extended. They sort of put in the first paragraph a very simple analogy to think about and more or less say that's what they think the congressional intent was. I
think they're closer to right than wrong. I just think that intent was too broad for its own good. But when I think it exceeds authority, that's what it means, right? When you go into a store and then you start knocking stuff off the shelves, right? You've exceeded your access authorization. You're no longer authorized to be in the store.
Right. So now the question is, there is the opportunity for Congress to change the statute. My guess is they just can't do anything with the current configuration of the House and the Senate, right? Realistically. Right.
Yeah, but I'm not, even if they could, I'm not sure there's like some wording that would get the job done.
Right. So then you get to what actually happens now, because let's say you had a case where you won on the CFAA and it's on appeal. And now there's an interpretation that essentially favors the employee or ex-employee or whoever it was that exceeded their authority. Is this retroactive or is this only prospective?
I think if you're in jail, it's got to be retroactive.
It's got to be retroactive in the sense that this is the right interpretation from day one, and therefore those cases all get reversed?
Yeah, although the reality is there aren't that many cases. I'm sure there are plenty, but in most of the circuits have actually gone the way the Supreme Court did for other reasons.
Okay.
But in most high profile, straight exceed access, the killer is for those people who pled out, right? Because then you don't have a right, you agreed.
Right.
You waived any right to appeal.
Right, but let's take cases, just stay with the hypothetical for a second, because the Ninth Circuit flip-flopped a few times on this case called Nozzle, right. NOSAL 1, NOSAL 2, NOSAL 3, and they kept going back and forth on this issue. So clearly there's a strong difference of opinion about how to read the language and how to read the intent and how to read what the statutory purpose is. But let's say you have a case, a civil case, that you won on behalf of the owner of the computers, and now it's on appeal. And the appellate issue raised, or let's say the appellate issue wasn't raised, but the briefing is still sort of open or the oral argument hasn't happened. Can someone come in and say, wait a minute, this is a whole new decision that goes in a direction that favors the abuser who was sort of an insider? You think the solution is change your terms of service or change your employee handbook and make it pretty clear and pretty strict, right?
Well, I mean, you've got two things. I don't think you can make it right because they say policy-based isn't enough. It can't just be strict. It has to be, under my theory, the only way it works is if you literally say your right to access the system is withdrawn if the reason you are accessing it is for an improper purpose.
Yeah, it's like a conditioned subsequent forfeiture, right? You have the authority, but it was forfeited. It's language of forfeiture, which is typically language that's viewed as abhorrent. But I want to turn to the ending of the decision for a second, just so you can take a look at it and tell me how you read this. She says, in sum, an individual exceeds authorized access when he accesses a computer, I guess he or she accesses a computer, with authorization, but then obtains information located in particular areas of the computer that are off limits to him. The parties agree that Van Buren accessed the law enforcement database with authorization. The only question is whether he could use the system to retrieve license plate information. Both sides agree that he could. Accordingly, he did not exceed his authorized access to the database. So that's like, to me, that's just like a wording game, right? He accessed the computer with authorization, and he had some ability to get at these license tag files, right?
Well, see, that's the interesting thing, right? He could, meaning he technically could get
Right.
access to it. He, under the policy, he had the right, he was entitled to get access to it. So, but that's just like the way you're right. It's a word game. It's the way the thing was written. What if it said you are not entitled to access the plate information for reasons other than X, Y, and Z?
Right. You could argue that they're kind of saying, look, if you really want to protect certain information, you have to put up splash screen robots that say, is your purpose legitimate? Please confirm under penalty of perjury that you have a legal purpose, you're not being bribed, whatever the list of conditions are. There are basically websites that do that, by the way.
I used to use that as a hypo in my internet law class. I would say, what if it's like an all-female website, right? Because it's for domestic abuse survivors.
Right.
And it says you have access to this only if you are a woman. Click yes only if you are a woman. You are not authorized to click no. And all you have to do is click yes, and it lets you in. And you click yes, and you're a man. Do you go to jail?
Right. Well,
theoretically, you're not authorized. It says right there, you are not authorized.
Right.
Do we really want to throw people in jail because they clicked yes to get into a website that's not password protected? It's publicly available on the web. You can probably get a deep link to via Google, via caching.
Well, you're kind of talking about the role of civil society and trusting people to tell the truth and the whole truth and to be honest, right? I mean, this guy actually got convicted of a Monell tort, dishonest government tort. There's a footnote that talks about how that got reversed on other grounds, but he basically was viewed as stealing from the government, but that was reversed as well. So this guy comes out okay, I guess, on his federal claim. I don't know what otherwise happened to him, but in general, the whole question of civil society and can you rely on people telling the truth and acting with honesty and integrity and good faith, or are we in kind of a rat race where unfortunately you have to take lots of technical precautions and send codes to a phone and make sure the phone is verified and put a million roadblocks up so it really does look like you're hammering into the site like a Russian fraudster, right?
Yep.
So let's go to the very end. This is Thomas's dissent. I've raced from the beginning to the end of both the majority as well as the dissent. It's 37 pages, which is a lot of pages for as simple a case as what this is. I think a Supreme Court from 100 years ago, if they had a case like this, would have decided in about 3 pages with maybe a 1-page dissent, but that's a different story. In the in the end, the act may or may not cover a wide array of conduct because of changes in technology that have occurred since 1984. Interesting choice to take 1984, the Orwell suggestion. But the text makes one thing clear. Using a police database to obtain information in circumstances where that use is expressly forbidden is a crime. And so there's almost like, hey, in this particular case, on these particular facts, where it's a dishonest cop accessing a database that is really restricted to only honest activities, it's almost like the dissent is like, look, maybe this is bad facts makes bad law, but we've got to uphold the law as against what this guy did and worry about the next case on a different day. That's the way I read it. But I don't know how you think about the dissent and this whole notion of bad facts making bad law, because now we have
I don't think this is
a muzzled act.
I don't think this is bad facts, though.
You don't think it's bad facts?
It's clear facts. That's why they picked this case. It sets it up clearly. Here's a guy who basically had he had authorization to access the database. Then he used the database for nefarious purposes. is that illegal or not? I mean, it's not a bad fact. It's the exact fact on a test, and the court has to decide: are you going to put a guy in jail for that or not? The majority says no. The dissent says yes.
Right, but you're not criminalizing.
I think it's good facts make good law.
Good facts.
What I think is bad drafting makes bad law, and Supreme Court is trying to fix the bad drafting.
Oh, so your argument's a little different. Your argument is the Supreme Court perhaps took this case as a way to say, Congress, you have to be very careful with wording that you choose, because you often choose wording that generates complications, right? Like, this is wording that was unnecessary. Maybe take the word "so" out. What if you take the word "so" out? What happens then?
I don't know.
I mean, you tell me. What would you think would happen?
I don't know. I think it's definitely illegal, right? You get authorization, and then you use it to obtain information that you're not entitled to obtain.
So you think it goes in favor of?
I think it's very similar. I mean,
the word "so" is irrelevant.
Well, it's irrelevant to the way the Supreme Court came out.
Right. So let's go ahead.
So that's the argument, right? The argument is the Supreme Court has read "so" out.
Yep. So here's the guy. Here's Van Buren. Okay. Maybe it is, maybe it isn't. This is the news reports. This is the beauty of having the web, right? You could argue, you could see so many different pictures you hadn't seen before. I assume this must be the lawyer who argued the case. You could say they're sort of siding with.
You can never tell from these Google image pictures, because it could just be the picture of some random dude.
Yeah, they could have just thrown a bunch of stuff in. You're right. Of course, they always have a lot of stock photos, right? I mean, is it hacking in a sense what this guy did? I mean, that's another way to look at it.
Well,
right?
It's not hacking.
It's not hacking, right?
But the CFAA covers more than hacking. So.
Right. Here's your point: the vote by ideology versus the vote by seniority, right?
Yeah.
Like, if you look at the vote that happens across different cases, there's a way to look at sort of how the votes go here. Vote by ideology versus vote by seniority. I mean, there's a lot of pictures like that. Anyway, that's the podcast, Mike. Do you have any other comments? I told you we would limit it to just 20 minutes.
I don't. I think we've covered everything that I would have to say about it. I mean,
I think it's a good teaching mechanism. I think it's a good teaching mechanism, this particular case.
It is. It's good. It's good teaching, and it's good for teaching statutory interpretation in the different ways people read the exact same law, right? I mean, here you have textualists writing both sides of it, coming to completely opposite conclusion.
Right.
So it leads you to wonder what the heck textualism is about.
Right. So just for people to know, you can get to hear the oral argument on C-SPAN, because they're doing this stuff, basically by phone, and it's all recorded. And I actually did listen to that oral argument, and I thought there were lots of questions by Breyer about, these words really need definitions and blah, blah, blah. And he sort of was of the view that it's just, it's a badly written statute, kind of your point, really.
Well, it isn't, and it isn't. I mean, it's a broadly written statute. The problem is the way it's broadly written is ugly, right? I mean, it leads to you don't mind this guy going to jail, but it would lead to a bunch of other people going to jail, and that is the problem.
Yeah. So. And the interesting part is, if you're a district judge, I guess you can get rid of a lot of cases now. If you got a lot of CFAA cases that go this way, maybe you'd say they could be saved by certain language, right? But it'll be interesting to see if we see a lot of motions and a lot of other decisions that now flow under this, sort of running with this idea. All right, Mike, thanks very much. I'll talk to you later. I got some new ideas for you that I'll talk to you offline about, okay?
All right, sounds good.
See you later. Bye.
Tune in next time on The Valley Current.